Okay, we're reconvening this hearing in Carolina Water Service. You're up. Would you know that clock's a little fast up there too? By the official timepiece, it's 1:21. You want anybody to question us?
Kevin Laird. I did. No, sir. Yes.
Testimony into the record, please.
We will enter Mr. Laird's pre-filed direct testimony into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Laird, were there two exhibits attached to your testimony, KL1 and KL2?
Yes.
Do you have any changes or additions, corrections you wish to make to those exhibits?
No.
Mr. Chairman, at this point, I would move the admission of exhibits KL1 and KL2 into the record.
Mr. Laird's exhibits KL1 and 2 will be entered as hearing exhibit number 6.
Mr. Laird, did you prepare or cause to be prepared 6 pages of rebuttal testimony pre-filed in this docket?
Yes.
Do you have any additions or corrections you wish to make to that testimony?
No.
If I were to ask you the questions in that testimony today, would your answers be the same?
Yes.
Mr. Chairman, I move the admission of the rebuttal testimony of Kevin Laird as if given orally from the stand.
Mr. Laird's pre-filed rebuttal testimony will be read into the record as if given orally from the stand.
Mr. Chairman, at this point, I would ask your the Commission's guidance on something. Mr. Laird's testimony, his direct testimony, largely pertains to the EQ liner issues that, as Mr. Nelson explained, are really no longer in controversy between us and the ORS. If it pleases the Commission, we would propose to stipulate Mr. Laird's direct testimony and move straight to his rebuttal testimony in the interest of time, with Mr. Laird being available to the Commission for any questions regarding the EQ liner that you may have. If you would like us to present his EQ liner testimony, we'll be glad to do so.
Is that okay with the parties, other parties? Okay. Ms. Valtorta, is that okay? Okay. Okay, so then it'll be stipulated.
Yes, sir. Thank you, sir.
We appreciate
it. We're going to discuss, as a summary, Mr. Laird's rebuttal testimony, which deals with the 40 left point issues Ms. Valtorta has been concerned with. Mr. Laird, please tell us, though, tell us what you do, who your employer is.
Goodwin, Mills & Kaywood, GMC, as you've probably heard it.
Okay. And what do you do for GMC?
I'm Regional Vice President, so I'm over operations and management for South Carolina.
And tell the Commission a little bit about your educational and professional background.
I have BS in Environmental Science from Clemson, a BS in Civil Engineering from Clemson, and a Master's in Engineering from Auburn.
Do you have any professional licenses?
Yes, I'm registered in the state of South Carolina, North Carolina, Georgia, and Alabama.
Have experience with water and wastewater utility?
Yes, over 18 years of experience.
And is Goodwin Mills Kaywood providing services to Carolina Water Service?
Yes, on a handful of projects. Yes, probably 6 or 7 projects right now, yeah.
Is 40 Love Point one of those projects?
Yes, that's right. Mm-hmm.
Let's talk a little bit about what you're doing at 40 Love Point. please tell the commission, what is GMC doing? Or are you involved in the 40 Love Point project, first of all?
Yeah, we have done, over the summer, we've done an assessment, gone around and really began, I guess, even before that. Our project manager is here, Leslie Joseph, and he has been attending the Homeowners Association meetings. He's probably been to at least 3 to try to fully understand what the issues are and where the issues are out at 40 Love.
And what are the issues that prompted your involvement in 40 Love Point?
So it appears that during rain events, heavy rain events, that there are 3 homes that back up consistently. So in those rain events, so that obviously has been an issue. Okay. So we've investigated that. Yeah.
And is your work limited to the 3 homes, or are you doing anything else there?
No. So in these homeowners association meetings, those are the 3 homes that we always heard about. Obviously, we encouraged confidentially any other homeowners that are having issues, please let us know, because that's important for what we're trying to do here. And we never got any feedback from any other homeowners other than the 3 homeowners. So we're looking to obviously have a very short-term, immediate solution for those 3 homeowners, but also look at a long-term plan that's the most efficient way to handle this in the future.
Tell us about the short-term work you're doing for the 3 homeowners.
Yeah, so we are. It's a LET system, so it's kind of a unique system.
It's a LET system.
All right, so it's somewhat of a hybrid between a septic system and a pumped system. Each home has a septic tank, and in the septic tank there's a solid side and then there's an effluent side. In that effluent side, that gravities to a collection line that goes around the lake at a constant elevation. There is a recirculation pump that has a little bit of pressure that provides that collection line that pushes that effluent, which is effluent. It does not contain solids, so it's effluent that goes to the Hiller Road pump station, of which Carolina Water owns. So that's what a LET system is.
Okay. We were going, and now let's go back to what you were doing for these 3 homeowners. What kind of problems are they experiencing?
So again, during heavy rain events, they have backups in their basement plumbing, as we understand it. And these are homes that what we're doing is we're going to put individual pumps in the effluent side of that septic tank. And what it will do is during periods of rain or any excess infiltration potential, that will be pumped up to a gravity line that's up in the interior of the subdivision.
Why are they having problems?
The best that we can determine is because these 3 homes have basement plumbing. That basement plumbing is in very close elevation to the existing LET's tank. So there's not a lot of head that can push the flow from the plumbing to the tank. And in addition to that, the tanks themselves, where the homes sit, there's not a long pipe that goes from the tank to the collection line that I spoke about earlier. So there's not a lot of storage potential between that LET's tank and the collection line. So when it backs up, it will back up into the basement plumbing.
And how will these pumps solve the problem?
Any excess effluent that comes into the tank can not only go to the collection line, but it can also be pumped out. So it will relieve the pressure that's on the tank.
When do you expect to have the pumps installed?
Next Friday, the 14th.
Have you communicated with the 3 affected homeowners throughout this process?
Yes, I feel like Mr. Joseph has done a really good job with communicating with the homeowners, not only what we plan on doing, but when we go out there to evaluate something, and then also the schedule.
Who's Mr. Joseph?
Raise your hand, Leslie. There you go.
So he's been the man on the ground.
That's right. Yes, sir. That's correct.
How about have you been tasked with looking at the long-term needs of the 40 Love neighborhood?
Yeah, we have. So, yeah, what was that?
I said, what are they?
So the long-term
So sorry.
So the long-term solution here is to have an additional pump station. What happens right now is when there's a rain event, Carolina Water has to send out basically septic trucks to pump one of the wet wells that's at one end of this collection system. Once they pump water out of that wet well, it relieves the issues. Now it's a problem because it rains and this happens before they're able to get out there sometimes. So what we plan on doing is installing a permanent wet well and pump station that can relieve that collection line, and it will pump directly to the Hill Road pump station, which is another pump station that is not in this subdivision. It's one that Carolina Water Service owns, but it's near the subdivision.
Have you discussed this plan with the homeowners?
Yes.
Okay. And what's the schedule for doing this?
So the schedule that we've provided has, I think it's the first week in January of having this pump station completed. So January the 7th is the date. Now, that's a construction project. Obviously, stuff can come up, but that's the date that we're shooting for to have the completion, construction completion.
How old is the LET system at 40 Love?
It's probably early 80s, mid 80s, something like that. I think that's what I've seen.
Are LET systems common or uncommon?
There's several around Lake Murray. They're not common in other parts of the country, but there's for whatever reason there's several around Lake Murray. There's other utilities that actually have LET systems around the lake.
Do you believe the LET system should be replaced at 40 Love?
No, I don't think it would be replaced. I mean, that's a pretty extensive and intrusive process. I think there's probably some maintenance, as we recommend, that can be done. Mm-hmm. And then there are some improvements of what I just described that I feel like will solve the issue.
What would you have to do if you replaced the LET system?
Well, I mean, it would be a pretty invasive process.
How's that?
Well, you would have to, in this particular case, you'd probably have to have individual pump stations at everybody's house, individual grinder pumps. So there's a couple hundred houses in the subdivision. So in addition to that, those would pump into a gravity system that's not there currently. That would need to be installed ideally in the roads, probably in some cases in the back of people's yards on some of the interior lots. So it would be significantly intrusive. I mean, you would ripping up roads, landscaping yards, driveways. I mean, it would be a major undertaking.
Think that would be a prudent thing to do?
No, I don't.
Mr. Laird, thank you. Please answer any questions that the parties may have for you or that the commissioners may have.
Sure.
Thank you. Ms. Valtorta.
Hello.
Hello.
Mr. Laird, have you visited other homes besides the 3 homes that have complained?
Visited other homes? Yes, I haven't. I mean, I've been around them. Yes.
So you went around the yard and saw the elevation and all that?
Visually, yes, ma'am.
Okay. So is it true that we have a lot of houses that are low-lying and close to the lake at 40 Love? Is that true? Did you see that?
Yeah, I mean, it's all relative, but it's really low-lying with regards to their LETS tank is some of the issue as well.
Okay. So this improvement that you're talking about, you're describing the permanent wet well and the pump station. Will that solve problems that other houses might have that are also low-lying and have basement restrooms and things like that?
Yeah, it will evacuate the water in the collection line.
So this will help everyone in the neighborhood, not just the 3 houses that have complained?
Yes.
Okay.
If they're having issues, we don't understand that they are, but if they are.
I'm just saying if they are.
Yeah.
Have you ever spoken to the Baileys? Have you been to their house?
I have not, no, ma'am.
Okay, sir, are you working on this project, or is it someone else who's under you?
Leslie Joseph is working on the day-to-day work of this, and he may have, but I'm not sure if he has.
Okay. And you sent me recently, I believe, an assessment of what was going on, and you could continue to do that. Is that true?
Sure, as we have been doing, yeah.
Right. Because I asked you for a summary of what was going on. I believe you sent me an email. But, okay. How good is that date, the first week in January of 2019?
It's something that we have told Carolina Water and DHEC, so it's a date that we definitely want to hit.
Okay, thank you very much.
Mm-hmm.
Thank you, Ms. Valtorta. Mr. Knowlton.
The question that comes to me as an intervener is, why has it taken so long? My understanding is this has been going on for years, and now we're coming to this, and even now, it seems like between the hearing in April when the order came down and what's been happening, that still months and months and months are going to go by, and no ground has even been broken yet. Do you have anything to say about why it's taking so long?
Yeah, I don't know. Honestly, before we got engaged, I can't speak to what happened before that. It was extremely high priority for Carolina Water, which they obviously relayed that to us. So we investigated the issue, came up to speed with what was going on, had to get permits even for this short-term solution, engineered the short-term solution, and it's under construction just really in a pretty short amount of time. So I would say that we jumped on a short-term solution to try to provide some immediate relief for these, especially these three homeowners.
Well, my understanding is that these three homeowners have gone for years with this problem, and if it was sewer in my basement or any of our basements, that would be way too long. Thank you.
Thank you, Mr. Knowlton. ORS. Thank you. Any redirect? Nope. Commissioners. Just forgot about these commissioners. Commissioners. Commissioner Williams.
Thank you, Mr. Chairman. Sir, you stated on page 5 of your rehearing testimony that the interconnection project approximately 11 months once the company receives a notice to proceed. Does that 11-month period include the remaining work for the EQ basin under the consent order?
Yeah, that work will be complete by the end of the first quarter of 2019. So ask the second piece of your question there. What was that second piece? I'm sorry.
Does it include the remaining work required for the EQ basin under the consent order?
Yes.
Once the interconnection project is complete, will the company be in full compliance with the DHEC consent order?
Well, the DHEC consent order was for the removal and disposal of grit and solids, and then the repair of the EQ liner. I don't think the 208 thing was in concert with the consent order, so that was something that was a little bit different topic. I didn't mean to interrupt, but the interconnection project will fix that second part of the consent order, yes.
Last question. So as you sit here today, do you see any obstacles or potential hurdles that could delay the time to complete the project?
Not any outside of a normal construction project.
Thank you.
Mm-hmm.
Commissioners, other questions? Okay, now we'll go to redirect. No redirect. All right, thank you. Okay, Mr. Laird, thank you. You
Thank
may
you.
step down.
Yes, I do.
Mr. Gilroy, would you please state and spell your name for the record?
Bob Gilroy or Robert Gilroy, Robertgilroy.
Mr. Gilroy, by whom are you employed and what do you do?
I'm employed by Carolina Water Service. Currently, I'm a special projects consultant.
And I should ask, just really for the benefit of the commissioners, council won't mind, what is the next step for you with respect to your employment at Carolina Water?
This is my last time testifying. At the end of the month, I'll be retiring and floating on a pontoon in Lake Murray.
We'd appreciate you not smiling so big about it.
All right, back to work, Mr. Gilroy. Did you cause to be prepared and pre-filed with this commission 7 pages of rehearing rebuttal testimony?
Yes, I did.
Have you had a chance to review your testimony prior to your appearance this afternoon?
Yes, I have.
Do you have any changes or corrections to your testimony?
No.
If I asked you those same questions today, would your answers be the same?
Yes, they would.
Mr. Chairman, I'd move Mr. Gilroy's rebuttal testimony into the record as if given orally from the stand.
Okay, Mr. Gilroy's rebuttal testimony will be read into the record as if given orally from the stand.
Mr. Gilroy, attached to your rebuttal testimony, have you attached 5 exhibits, A through E, to your testimony?
Yes, I have.
Have you had a chance to review those exhibits prior to this afternoon's appearance?
Yes.
Do you have any changes to those?
None.
Mr. Chairman, I'd move the 5 exhibits into the record as a composite exhibit at this time.
Okay, Mr. Gilroy's 5 exhibits, RHG A through E, will be composite exhibit number 7.
Mr. Gilroy, for your benefit, I'd refer you to page 6 of your pre-filed testimony, and I would ask you to please summarize the facts showing that the town of Lexington is responsible for the failure to connect the I-20 system to the town's regional line.
Yes, and I'll revert to my testimony on here because there's some dates and I want to make sure I have this right. The town did not have the capacity to take the I-20 flow when its regional line was permitted by DHEC in 1999, as is shown by the July 2000 agreement between the town and DHEC. The town's proposed wholesale rate rejected by the commission in 2003 was unreasonable, and I believe that the town set it at a high level because it did not have capacity available to provide CWS wholesale service at that time. The town, unbeknownst to CWS, entered into its 2009 contract with the city of Casey and issued bonds which precluded a wholesale service arrangement. The expansion of the Casey treatment facility came online in the fall of 2012, and in the summer of 2013, the town acknowledged to me that it owned sufficient capacity in the Casey Regional Treatment Facility to take the flow from the I-20 plant, but stated that it did not have sufficient pumping capacity to transport the flow from the I-20 system to that Casey wastewater treatment facility. And with respect to an agreement for the sale of the I-20 system to the town's offer to purchase it for about 1/3 of the I-20 rate base reflects an effort to leverage the threat of penalties sought by the CRK or Congaree Riverkeeper in federal court action to force CWS to accept less than fair market value.
Thank you. Does that complete your summary?
Yes.
Please answer any questions council or the commissioners may have.
Thank you. Ms. Valtorta? Mr. Knowlton? Okay. ORS? Thank you. Okay.
Afternoon, Mr. Gilroy.
Good afternoon.
Explain for me, if you will, a little bit on your testimony. Is it your contention or is it CWS's contention that the town worked in concert with the Congaree Riverkeeper in these two actions, the condemnation and the Riverkeeper's federal court case?
Yes, it is.
Let me ask you to please turn to your Exhibit E. On the first page of your Exhibit E. And this is a series of emails, apparently, between an attorney for the town of Lexington and Bland Holman, who was with the Southern Environmental Law Center. Do you know where these came from?
I believe they came through discovery motions.
Okay. Discovery in the federal or the town
Yes.
case? Okay. All right. Could I just have you read, and these are in backwards order, I guess, bottom to top. Could you just read these two on the bottom half of the page? You want to read the whole page? That's fine. But could you read these two from the bottom of the page? The one from Bland Holman dated August 4, 2014, 2:37, and the one from Brad Cunningham to Bland Holman dated Monday, August 4th, 2014, 2:43 p.m. Could you read the body of, beginning with the one from Mr. Holman to Mr. Cunningham, please?
Yeah, and so that's going to go from bottom to top, right?
Yes, it is going to go from bottom to top. Thank you.
Okay, let's see. From Blaine Holman to Brad Cunningham. Thanks, Brad. As you know, my client has signaled his intent to sue CWS over failure to hook up per the 208 plan incorporated into CWS's MPDES permit. Client wants to know if filing a complaint, how would be, and that's what it says, complaint now would be helpful to negotiations. I could see being potentially helpful, but also potentially disruptive. I'm on my cell, and he gives a cell number if you got a second.
And then the second one, which is the one from Mr. Cunningham to Mr. Holman.
Correct. At this point, it would be more likely disruptive, in my opinion.
So isn't the town, in fact, signaling the Congaree Riverkeeper's lawyers that it would be disruptive, actually, to their condemnation action to bring that federal lawsuit?
On this page, but I think in subsequent communications, it's not.
Okay. That's the only one I'm looking at right now. Thank you. Can you explain for the commission a little bit? We've had some discussion. Could you explain what a 208 plan is?
A 208 plan is it's set up so you have regional facilities to treat waste, because there's so many smaller facilities around. So the COG sets up. Through the COG, there's a 208 plan set. It's basically
and the COG is? Thank you.
And I believe that's once they come up with this plan and then it's okayed by EPA, you have regional providers, designated regional providers for the 208 plan. So in other words, smaller plants have to, at some point, they're classified as temporary plants. At some point, they have to connect to the regional provider.
And that the intent of that is to, reduce
discharges into the rivers, streams, and bodies of water, and just reduce the total number of plants, basically consolidated into less.
Is there one 208 plan that covers the Midlands area of South Carolina? Or are there several? To your knowledge, if you don't know, that's fine.
Well, no. For this one, there's one plan for the Midlands, yes, but there's multiple providers. The City of Columbia is a provider. Richland County is a provider.
Okay, but one plan.
Right.
Okay, and that's a EPA, DHEC. Somebody signs off on that as far as the government goes. Is that correct?
Yeah, and I'm not positive about that, but the EPA would be the one. But I'd defer that question to someone a little bit more knowledgeable in that field.
The 208 plan we're talking about here that covers the Central Midlands when was that 208 plan entered?
I don't know the exact date.
Does 1998 sound familiar?
It may be. I don't know it.
Do you know when? How long have you been with the company, by the way, Mr. Gilroy?
Since 1989.
Do you know when a first attempt was made by CWS to interconnect to the town of Lexington under the 208 plan?
Not the ones that I know of, that I'm aware of, are in my testimony here, and I believe it goes back to 1996.
Okay. So that would even predate the 208 plan?
It may, yeah.
Okay. What type of negotiations took place? Because we've a lot of these legal bills and everything deal with this condemnation action that's currently pending.
There were several.
Okay. And I guess I noticed one. I think it's your Exhibit C. Is March 21, 2014, and that's, I guess, one of the occurrences that happened trying to do the interconnection. Is that correct?
That would be the letter from Richard Durham?
Right, yes.
Yeah, that would be involved.
Okay. Was this the first written offer to do this interconnect? What had preceded this?
No, sir. What preceded that, there's Exhibit A or whatever. That's my communications with the town of Lexington asking for the availability of capacity in the plant.
Was
their line.
What
that was 2011 when I began that.
Thank you. What was the effort? Was it to just do an interconnection to flow CWS's, the I-20 plant waste to the town of Lexington, or was this part of what eventually turned out to be the condemnation? Was that also part of the effort?
No, it wasn't part of the condemnation. That was most recent. Back in 2011 is when I asked for the availability of an interconnection from the town. Didn't get a response. And then Casey upgraded their plant in 2012. So in 2013, I again wrote to the town, asked them about the availability. And I'm not sure. Hold on. Yeah, in 2011, I asked for availability for an interconnection in an email form to Alan Lutz, who's the utilities director. I didn't get a response on that one. In 2013, after learning that the Casey plant had completed its upgrades, that's when I sent another communication to the town of Lexington and asked if they had availability to accept CWS's flow through an interconnection. Their reply at that time was, while Casey had upgraded their plant, they did not have the pumping capacity in their transmission line at the time until a new lift station is built sometime down the road to take that flow.
Was there another option besides interconnecting with the town of Lexington, or is this the only option that the I-20 plant had?
Well, the only feasible option is interconnecting with the town of Lexington. They built that line. They built it right there in proximity to the plant, just several feet off the property, as a matter of fact, and there isn't another utility around. The city of Columbia or Casey doesn't have lines.
So what happened? I mean, we started this 208 plan and attempts to interconnect way back in the late 90s. Here we are finally at 2018, I guess maybe a year ago or whatever. Something happened with the condemnation. What took 20 years to work out? What was the central issue here?
To my knowledge, it's the town of Lexington saying no.
Is it the town of Lexington, or is it what the town of Lexington wanted to charge or pay CWS?
I think it's what they wanted to charge, I believe. And again, I'm checking my notes because there's a lot of dates involved here. There was the first go around in '96. I believe the commission rejected a sale of I-20 to the town. And then again in 2003, the commission denied a wholesale agreement for an interconnection with the town simply because of the rates or the cost of what the town wanted to charge per connection for an interconnection.
Where, to the best of your knowledge, does the condemnation action stand now? Is it finalized? Are we done with it? Are you done with it?
I think it's still with the condemnation court. I'm not fully involved in that any longer, so I haven't been keeping up with it, but I know it's still in that process with the court.
One more question for you, Mr. Gilroy. Sludge expenses. I'm going to get off the other topic for a minute here. There was some discussion about, and it wasn't you, it was one of the prior witnesses talking about an increase in I&I work on the Friars Gate system. Is that true, that that's something that y'all are involved in right now?
Yes, there is a work being done as far as I&I in the system. But I'm not fully engaged in that any longer, so I'm not up to date on exactly what's going on.
Does that work on improving the INI on the system? Does that increase your sludge?
No, I think that work will take years, and I think it has the opposite effect. It reduces flow.
So so eventually it will end up what? We're trying to get to what the INI does and what the program is here to fix it. So you've got a program underway right now. Can you explain a little bit about what that program entails?
Well, I know it's to address the current INI in the program, but as far as the details, I think maybe Mr. Laird or someone else can answer that more informative. I apologize, but I haven't been involved in it in a little bit.
Okay. Thank you, Mr. Gilroy. Appreciate it.
Thank you, Mr. Nelson. Commissioners. Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Mr. Gilroy.
Afternoon.
You've got a good bit in your rebuttal testimony about the efforts to connect to the town of Lexington's lines, and of course, Mr. Nelson has also questioned you on that subject just now as well. I think in looking back through the litigation costs, it's fair to say the largest portion is the part that the defense of the CRK, Congaree Riverkeeper case. Would you not agree?
To tell you the truth, I would not know because I'm not involved in the finances as far as it goes with the attorneys.
Okay, well, they had the chart on the screen a little earlier today, and I want to say it was close to 40%, certainly in the 30% range, and seemed to be the largest legal expense out of the whole figure by itself. And my question is going to pertain to that. Obviously, you're familiar with Ms. Hipp's testimony because that's what your rebuttal revolves around. But if you need to, I'll give you a second. I want to refer to Ms. Hipp's testimony, page 11. Probably looks like around lines 15 through 18. Okay, I'll give you a second to get a copy of it because I'm going to refer to that. Yes, sir, page 11, round line, starting with round line 15, Ms. Dawn Hipp's testimony. Ms. Hipp states that the company, if the company had properly managed the I-20 system in accordance with the NPDES permit, then the CR case could have been avoided, and the legal fees resulting from the company's defense in that case would not have been necessary. My question to you is what prevented the company from operating its system in accordance with that NPDES permit?
Well, the permit said that when there was availability in the regional provider of the 208 plan, which is the town of Lexington, that we must connect. And in every corner, the town of Lexington denied us connecting for one reason or the other. So we couldn't connect. We couldn't forcefully connect. We couldn't do it in the middle of the night. So we had to have an agreement for connection, of which we could not come to terms with.
And that's the only part you feel like you violated of the permit? Or I know the permit specified for you to do that, and you've, of course, stated repeatedly to Mr. Nelson, and again gone through it pretty much chronologically, the number of times and efforts you made to connect.
Correct. That's.
And of course, you had a separate legal expense, not nearly as high, but a separate legal expense from that.
Yeah, I think the whole question of whether we're violating the permit by not connecting, as the permit stated we must.
All right, Mr. Gilroy, that's all I have, Mr. Chairman.
Thank you. Commissioner Elam.
Hey, good afternoon, Mr. Gilroy. During this period, the 98 to, recently, did the I-20 plant undergo any capital improvements? Or was it just you were supposed to interconnect, so why would you make capital improvements?
Yeah, I think I'm going back because I wasn't managing the I-20 plant at that time. There were improvements made to basically updating lift stations, collection system, those type of things. But as far as the plant goes, there was work being done at the plant as we went along. The permit's been expired for a good number of years, so there were no, and it's been classified as a temporary plant working under an expired permit, so there were going to be no major upgrades.
Okay.
In that case.
Thank you.
Any other commissioners? Okay, if not, any redirect? Be careful.
Follow up questions that Mr. Nelson had before you about your Exhibit E to your testimony. If you'll go there, please. Now, Mr. Nelson asked you about the first page of that exhibit. I'd like you to turn, if you would, please, to the roughly the fourth page of that exhibit. It's actually got a bait stamp number at the foot, 196, TOL 196. Do you see that small number there?
Yes, at the bottom right.
Correct. Now, reading from bottom to top, the email at the bottom is from a Heather Murray, and either from your reading of this email or from your knowledge, however limited, of the Riverkeepers litigation, do you know who Heather Murray represents in that litigation?
The CRK believes she's with Southern Environmental Law.
Thank you. And the email is to a David Black at Nexon Pruitt. Do you know who Mr. Black represents?
Represents the town of Lexington.
Thank you. And publish that email from Ms. Murray, please.
The bottom of the page?
Please.
Hi, David. Please find the draft affidavit attached. Don't hesitate to contact us with any questions.
And it says, thanks, Heather.
Thanks, Heather. Yes.
Turn the page, please. Do you see that document that's labeled Affidavit of XX?
Yes, I do.
And do you understand that this affidavit was sent to Mr. Black by Ms. Murray in her email of February 25?
Yes, I do.
And going up the page to the middle of the page, second email. Do you recognize the name Catherine Wanamaker?
Yes, also with the Southern Environmental Law.
And she sends an email to David Black. Would you please publish that email?
From Catherine Wanamaker to Heather Murray and David Black. Hey, David, just thought I'd check in on this affidavit. Have you had a chance to look it over, to talk to the town folks about it? I think we are about to extend discovery through April in our case, but we probably need to turn this over to them in the next few weeks if we plan to use it. Thanks, Catherine.
Thank you. And then reading up the page, do you see the email from Mr. Black to Ms. Wanamaker?
Yes.
Would you please publish his email?
Even better, please see our amended answer, counterclaim, and verification. In parentheses, language you need is in the counterclaim facts.
All right, and so do you understand there that Mr. Black is sending the town's pleading to Ms. Wanamaker?
That's the way I took it, yes.
And then publish the last email on that page at the top, please. Who is it from?
From Catherine Wanamaker to David Black.
Right, and what does Ms. Wanamaker tell Mr. Black?
Okay, great, we like it. Wondering if we still need the affidavit, but we can discuss.
And so what was your purpose of including this exchange in your testimony?
Basically, in my opinion, it was the Riverkeepers representatives working with the town of Lexington in the case, in my opinion, to, I guess, do what they could to lessen the value. How could they help lessening the value of the property?
I don't have any further questions. Thanks, Mr. Gilroy.
Recross by the parties. Thank you. Okay, Mr. Gilroy, you may step down.
Thank you.
Higher to the lake.
Thank you very much.
Okay. Unless there's an objection, anybody? I think they all want you out of here. Okay. Next witness. You know, I do public address for football. I needed my binoculars.
We're going to try to help.
It's attached in your testimony. Okay, it's one of the exhibits, and highlight that when we enter all that.
Spell your name, record.
Push that little button right on the front till that red light. You're on.
On now? Okay. Keith, Keith, Moss, Moss, Babcock, Babcock.
Thank you, Mr. Babcock. And by whom are you employed, and what do you do?
I'm an attorney, and I'm employed with the law firm of Lewis Babcock, LLP.
And did you cause to be prepared and pre-filed with this commission revised direct testimony in this docket?
I did.
In fact, did you cause to be prepared and pre-filed 10 pages of revised testimony?
I did.
Have you had a chance to review your testimony prior to your appearance this afternoon?
Did?
Do you have any corrections or changes to your testimony?
Still, like one small one, I noticed when I was reviewing my testimony this morning on page 9, where I was going through the various factors to be reviewed for the reasonableness of attorney's fees. I had quoted all of the factors except for the third one. If you look at page 9, line 6, where it says fee customarily charged, that should have been in quotes. The language is correct. I just should have had quotes like I had quotes for the other. That's
Quotes surround the entire paragraph?
No, it should start, the third factor is, and it should start with the fee customarily charged in the locality for similar legal services. End of quote, there, yeah.
Any other corrections or changes to your pre-filed testimony?
No, sir.
If I ask you those questions this afternoon, would your answers be the same?
Yes, sir.
Chair, I would move Mr. Babcock's revised direct testimony into the record, given orally from the stand, as he has.
Mr. Babcock's revised pre-filed direct testimony be read into the record as given orally from the stand as he sort of revised it then, to quote you.
All right, Mr. Babcock, attached to your revised testimony are 4 appendices. Have you had a chance to review those prior to your appearance this afternoon?
Yes, sir.
Do you have any changes or corrections to those appendices?
No, sir.
Chair, I'd move those 4 appendices to his pre-filed testimony into the record as if given orally from the stand.
Okay, Mr. Babcock's appendices A through D will be entered as exhibit number 8.
Thank you,
Mr. Elliott, if I might, for the Commission's benefit, the chart that we were referencing before I began testifying appears at Appendix B to my testimony.
B, that way all parties can, everybody has a copy of that, right?
Babcock, on whose behalf are you presenting testimony in this matter?
I am presenting testimony on behalf of Carolina Water Service, Inc.
First, would you please summarize your educational background and employment experience?
I received an AB degree from Princeton University in 1973. I received a Juris Doctorate from George Washington University Law School with honors in 1976. I then began work at the South Carolina Attorney General's office under Attorney General Dan McLeod, which is where you and I met. And I was there from 1977 to 1981. I then went into private practice, and in 1984, I formed, along with Cam Lewis and Johnny Gregory, the firm known as then Lewis, Babcock and Gregory, and it has had different names over the years, but Mr. Lewis's name and my name were always the first two, so it's now Lewis Babcock.
Mr. Elliott, the folks in the back can't really hear you very well, so make sure you get that mic close to you.
Thank you. All right, Mr. Babcock, what's the purpose of your testimony in this proceeding?
The purpose of the testimony is to present the Commission with my opinion concerning the reasonableness of attorney's fees that CWS has sought in this proceeding.
And have you formed an opinion as to the reasonableness of these attorney's fees?
I have, and one thing perhaps before we get to the opinion for the Commission's benefit, during my entire time as an attorney, I've been a trial and appellate attorney. That's what I do, and I started that way with Mr. McLeod's office, and I've continued there in private practice.
Thank you. Having formed an opinion, what did you do to form it?
Well, I first met with you, Mr. Torini, and Mr. Hafer at Mr. Hafer's office, and Mr. Hafer gave me an overview of generally what had occurred and why. And what's important here is there are 5 different cases that form the basis for these attorney's fees. So I needed to understand what the different cases were and what was at issue in each one of the cases. After we had that discussion, I asked to see a number of different documents, the pleadings, motions, various court filings. That was primarily my focus point, and then look at all the legal bills. So I pulled all that material together because I thought that was the way to attack the question of the reasonableness of the attorney's fees.
Good. Please address the attorney's fees associated with each of these actions.
All right. The chart, which is Appendix B, sets forth, and by way of backdrop, perhaps, you've got two federal court cases. One is the Riverkeeper lawsuit, and the other it was a lawsuit against the EPA. There are two ALJ cases, both involving the DHEC permit. And then there is the condemnation case. Now, maybe if I could explain those cases a little bit, would that be helpful?
Please.
All right, so you've got the condemnation case, and I started with that case because I do a lot of condemnation work. So that was of interest to me. And condemnation cases, there was a time, as Your Honor would remember, when condemnation cases were pretty run-of-the-mill. Lots of people tried them, and they weren't all that difficult. And the reason they weren't all that difficult was because you eliminated the issue of liability. All you had in a condemnation case at its heart was the issue of just compensation to the landowner. And just compensation involves two components. One is the value of the land acquired, and the other is any damages to the remainder. So that's what the cases are about. And when I started trying them, they were relatively straightforward. But over the years, as you've had more complicated, and it's primarily commercial takings, when you have transactions that involve businesses, even though the business loss does not come in directly, they typically have the greater value for land and the damage to the remainder. So they've gotten much more complicated over the years. And when I started, you didn't do a lot of discovery. You just went to trial. You had a little folder, and you could try your case. Then they got more complicated, as lawyers tend to make things. And we started doing a lot more discovery, and that meant a lot more depositions, more different kinds of experts. In addition to an appraiser coming in to testify, you would frequently have predicate witnesses in terms of land use planners or engineers, that sort of thing. So over the years, they've become very involved cases. Not all, but a number of them have. This is a particularly interesting case to me because I've never seen one quite like it. In this case, the town of Lexington is acquiring, or has acquired, because in condemnation, you acquire the property when you file your notice of condemnation and you pay your deposit into the court. It's called a quick take. That gives you right to take immediate possession of the property. So in this case, what you had was an ongoing business acquired by the town of Lexington. In my opinion, it would be inequitable to simply compensate CWS based upon the value of the real estate and the mortar, bricks and mortar. Since you had an ongoing business taken, I think the only way they can get compensated would be being paid for the ongoing business that the town of Lexington is now operating. So that's a novel issue. And one I kind of wish I was involved in the case in, because it has a way to create new law in South Carolina. This is a rare thing. This doesn't happen very often. I'm aware of a situation in a port, I think down in Florida, maybe New Orleans, where they did a similar thing. The town acquired an ongoing business. And so I think ultimately the South Carolina Supreme Court is going to be the arbiter of, unless they settle it, of whether when a condemnor takes an ongoing business, that it then operates. And that to me is a critical issue. If they were just taking it and not operating it, then you're into a more normal condemnation setting. But when you take it and operate it, the only way you can get full, fair, and just compensation, which is a phrase I always use when I'm trying a case, because I'm normally for the landowner, the only way you can get there is to pay for the value of the business they took. So it's a fascinating legal issue, but that makes for, here's the problem. Anytime a lawyer says, that's an interesting legal issue, or in my case, that's a fascinating legal issue, what that means is it's going to be expensive. And because it's going to be a lot of time, a lot of research, a lot of motions, a lot of arguments, stuff I love to do, but unfortunately, clients are going to have to pay for it one way or the other. So anytime you hear that interesting or fascinating legal principle, hold on to your wallet.
Good.
Now, do you want me to address the legal fees? I've broken down on my chart for each year, because I thought the only way to look at this in a fair assessment was to look at each year and each case. So I've broken down in the chart each year, and you'll see 2015, 2016, 2017, 2018, and then a total at the bottom. So if you go over to the right-hand column, you can see for each case by year how much the attorney's fees and costs were, and then it's totaled up on the right-hand column. The other column, which we'll get to in a minute, is the Willoughby and Hafer column, because they did the primary work. That's in the first column. So, for instance, we can go through these one by one, but I don't know that we need to.
I think not.
Okay, so if you want to look at the totals, on the total column, the last column, you've got total Town of Lexington versus CWS condemnation, and if you run that out, you can see how much Willoughby and Hafer and how much for total. And the same thing for each one of the other cases.
Good. Thank you. Please discuss the cases in federal court.
Okay. And they didn't have quite the same fascination to me that the condemnation case had, but you've got your primary case is the Riverkeeper case. And in that case, you've got an effort by the Riverkeeper to attack the CWS's compliance or non-compliance with the permit. It was interesting to me in that case that you didn't have DHEC bringing the case, and you didn't have EPA bringing the case. So normally, and I can speak about DHEC with some knowledge because my wife has been in the general counsel's office. She's deputy general counsel since 1977. She's had one job since 1977, which is pretty remarkable. Also one husband since 1975. So that's all to my benefit. But in the Riverkeeper suit, you had the Riverkeeper who had the right to bring the action. There's no question that he had the right to bring the action. But he's attacking the non-compliance with the permit. And to me, well, it was an interesting legal question because you had the question of definitions that Judge Seymour got into. But basically, at the end of the day, you had a situation where the company had three options. Or I guess a fourth, which is non-compliance, but one was the interconnection. That was the one they wanted, and they couldn't get it. The second was to sell the whole operation, which in effect is happening by way of the condemnation case. It's a forced sale, but that's effectively what's happening. Or to stop service to the people. And I think if they had taken that option, this commission would have been awfully upset about that. So they were stuck. And they were stuck in the litigation because when you get, and let me back up, federal court is, with all due deference, tougher than state court, primarily because they've got all kinds of filing requirements. You have to file so much more paper in federal court. You've got tough deadlines. And in federal court, you not only have the federal rules of civil procedure, you've got the local district rules, and you've got the individual judge's preferences. For some reason, a few years ago, we decided that it wasn't good enough to make lawyers comply with the first two, that we were going to make lawyers would have to go with whatever judge you are. You've got to go check his or her preferences. So it's really hard. And I love federal court. But what you find is there are many more state court practitioners than federal court practitioners. So you've got intense time, deadlines, filings, and they're unforgiving. I made the mistake a few years ago of, this shows you how intricate these are. If you file something with the court that is more than, this is before, maybe it was after you filed it, but if it was more than such a number of pages, the judge's preference was that she also get a hard copy of whatever it was. And I had failed to do that. We just didn't do it. The next thing I know, I had a federal clerk, her clerk, calling me up and saying, Ms. Babcock, you filed this document. It's more than 50 pages, 100 pages. And you didn't send, it was Judge Curry, you didn't send Judge Curry a hard copy. I said, oh my goodness, I'm sorry. We'll get it over to her right away. She said, well, Mr. Babcock, if you're practicing in federal court, you have to follow the rules. And I said, yes, I know that, and we'll make sure we follow the rules. But that's the kind of thing you're facing. And you have to bow and scrape when the federal court tells you need to bow and scrape. But the point is, it's tough, and once the Riverkeeper lawsuit was brought, CWS had no choice but to fight as hard as they could because they had no option. They couldn't just say, we don't want to be in federal court or we don't want to have this lawsuit. So that was a long, hard fight. The other federal case was an effort to try to get EPA to change the was it
208 plan.
208 plan, or to force the interconnection. And I think that was a long shot, but I think the idea of bringing that case was an excellent one because it was one way to undo the logjam. And if it had been successful, it would have been great. And it was much less expensive than the other case. So I thought that was a good legal strategy. Ultimately unsuccessful because that's the only case of all the cases we've got. That's the only case that's finished. All the other cases are ongoing. And just to complete the case analysis, the other two are the ALJ cases, and one of those is a primary case, and it involves the fight about the DHEC permit. There's a secondary case which had to be filed because there was a short time frame if the permit was ultimately denied, that they had to have a submission. So that was a protection appeal to ALJ because they had to protect the time limit.
Before we go beyond these cases, I do want to refer you to your pre-filed on page 5. Would you please describe the effectiveness of this aggressive defense in the federal Riverkeeper case, especially concerning the $1.5 million fine that was assessed and is now vacated?
Right, and there are really two parts to that. Number one is the position in the underlying case, which is at its heart that CWS was unable to do what was being required. And I think when you look at the interconnection, you're basically talking about two parties doing a deal. But it takes two parties being willing to do a deal. And if you didn't have a willing party, even though CWS was under a permit requirement to do it, they couldn't do it on their own. So they were stuck there. And to me, you can't comply with it. Now, I'm not a federal judge, and Judge Seymour, she's been a judge a long time, and I'm certainly not going to be critical on the record of a federal judge about anything. But the one thing she did do that the attorneys were able to undo was a $1.5 million fine, which is, to me, astounding when the company could not do what she wanted them to do. That penalty has been vacated. Now, there's still a legal issue about that. It's not entirely off the board, but they got the $1.5 million number off the board and the penalty off the board now, and that was good legal work.
Now let's turn to the issue of the reasonableness of the attorney's fees. And you've got your spreadsheet in front of you, and we have it here on the screen, every screen, and in this blow-up. Would you just discuss briefly the costs by year for Willoughby and Hafer?
All right, and again, I focused on the Willoughby and Hafer bills. I looked at the others, but the far greater percentage was with Willoughby and Hafer. And I want to talk about them in a minute, Mr. Elliott. But looking at the Willoughby and Hafer chart is the first one, and if you look at it by year, 2015 would be $106,371.97. 2016 would be $506,850.53. 2017 would be $332,808.44. There's nothing shown for 2018 because that period was only the first 2 months of this year, and they apparently just didn't bill for those 2 months. So we got nothing, no numbers there.
Good. Now, are you familiar with Willoughby and Hafer?
I'm very familiar with Willoughby and Hafer. I first met Mitch Willoughby through his wife, B.J. Willoughby. She was with us at the South Carolina Attorney General's office. So I met Mitch in an early day as a spouse of one of the lawyers at the office. I met Mr. Hafer in the late 80s or early 90s. It was either before or after his deployment to Afghanistan, but it was right in that time period. And then I met Mr. Lowell probably 10 years or so ago. I've had some work with him, and I've been able to see his work as an environmental attorney very closely since about 2011. He's involved with a mutual client, so I've been able to see what he's been doing for that client. And finally, Mr. Johnston, I met him a few years ago, and he and I have had some cases, I think 1 or 2 cases since he went to the firm. They are all outstanding lawyers, particularly Mr. Hafer and Mr. Lowell. Mr. Johnston's a younger lawyer, and from my perspective, almost everybody's a younger lawyer, but Mr. Hafer and Mr. Lowell are very good trial and appellate lawyers, and Mr. Lowell is so good, and he'll tell you about this, that there's a South Carolina Supreme Court case from a few years ago which referred to him as an environmental scholar. And I guess if I had a South Carolina Supreme Court that talked about me as being any kind of scholar, I'd be pretty proud of it too. But that's what the South Carolina Supreme Court doesn't just throw words out there. If they put those words in there, they showed tremendous respect for Mr. Lowell. And Mr. Johnston's just a very good younger lawyer. I'm sure if I were around 10 years from now, I would be talking about him in those kind of glowing terms. He's a lawyer who's on his way, and he's quite good.
Now let's look at the attorney's fees and cost, if you would, please.
All right. I thought it was instructive, and when you get into fees, and I'm going to talk about the factors in a minute, but in trying to judge what would be appropriate fees for lawyers of different levels of experience, there was a filing by Tom Tisdale in the Riverkeeper case when they filed a motion for attorney's fees. And Mr. Tisdale is a past president of the South Carolina Bar. He's practiced in Charleston for years. He's extraordinarily well respected down there. And he opined that, in his opinion, typical billing rates for attorneys with over 20 years of experience would be over $400. Attorneys with 15 years of experience would be in the $350 to $400 an hour range. And attorneys with 4 years of experience would be in the $250 to $300 an hour range. And I think that is an accurate assessment of attorneys' fees in urban areas in South Carolina. I think you see a little different billing rate in some of the more rural areas, but this would be very typical for urban areas. So I looked at that rate, and I think he's right. And I looked at what the rates were that were charged by the Willoughby and Hafer firm. And to be quite honest with you, when I first saw them, I was astounded because they were significantly lower than I would have expected. John Hafer charged $315 an hour. Randy Lowell charged $270 an hour. And Chad Johnston charged $225 an hour. And I was just very surprised by that. So I spoke to Mr. Hafer, and what he told me was consistent with his affidavit, that CWS had been a long-time client of theirs, and they had arbitrarily low rates because of that long-time relationship. And those are, as I say, significantly lower than I would have expected the rates to be. But I understand we all have certain situations when we have long-time relationships with clients where we have a different billing arrangement. So it was entirely appropriate, and it was to everybody's benefit, I guess other than Willoughby and Hafer, that they charged these lesser numbers, because higher numbers would have been reasonable, just as I found their fees and bills to be reasonable.
In assessing the reasonableness of the attorney's fees and cost, what standard did you use?
Well, I try to listen to courts when they tell me something, and in the rehearing order, as I understood it, the commission was directing somebody looking at the reasonableness of fees to go to page 27 of order number 2006-543 in docket number 2006-92 WS, and there what the commission did was to look at Rule 407 of the Appellate Court rules, and specifically Rule 1.5. Now, this rule is part of our ethics rules, and it gives guidance for what lawyers can and can't do. So this rule talks about the different factors, and there are 8 of them, for the reasonableness of attorney's fees. And so that's the Supreme Court saying these are the factors from an ethical standpoint that would make for that you would use when you're looking at attorney's fees. There in civil and in domestic, there's a slightly different standard. Glasscock versus Glasscock and Jackson versus Speed. They list 6 factors, but really, when you break them down, they're basically the same. It's just that the Rule 1.5 has 8 factors and the civil factors are 6. But when you get down to the end, it's basically the same analysis. Would you like me to go through the analysis?
Go through them, all 8, please.
Okay. Well, the first factor is the time and labor required, the novelty and difficulty of the questions involved, and the skills requisite to perform the legal services properly. So, looking at the invoices, I think the Commission, I'm sure, has them available to them. I think if you look at the specificity with what was done, we know, I've talked about the individual lawyers. These cases were quite difficult, particularly 3 of them: the Riverkeeper lawsuit, the condemnation lawsuit, and the DHEC permit issue. Those are tough and significant cases. So if you look at those cases in particular, only experienced and skillful lawyers would have undertaken the cases, and there's no question but this firm fits in that category.
Let me interrupt you 1 second,
Sure.
if I may. The issue has arisen over the recovery of attorney's fees to the prevailing party in condemnation cases. The Commission would benefit from knowing that law.
Hesitant to tell a former judge what the law is, but the eminent domain code was passed by the General Assembly in 1987 or 88. Prior to that, each condemning authority had their own statutes. So if you wanted to see the condemnation procedure for a utility, you went to one part of the code. If you wanted to see the condemnation procedure for a county or a city, you went to another part of the code. And if you wanted to see the condemnation procedure for a state agency, you went to another part of the code. Now, that actually worked pretty well for those of us who worked in the area, because we knew that, and it was harder for other people to figure it out. So it gave us a leg up. But that really wasn't fair. It wasn't fair across the board. So in 87 or 88, they passed the eminent domain code, and they pulled all together all the statutory procedures for condemnation. And eminent domain and condemnation are the same thing. So I switch back and forth between the terms, but they're the same thing. So in the eminent domain code, there is a provision for attorney's fees and costs to be awarded to the prevailing party. And that's the phrase that's used, prevailing party. And prevailing is defined as being closer to the landowners, and let me back up. Only the landowner's attorney can get the fees and costs. The government can't. So in the prevailing party scenario for the landowner, if the jury's verdict is closer to their high testimony, in other words, the highest value put in evidence by the landowner, in comparison to the highest value of the condemnor's testimony. If it's even just $1 closer, the landowner would be considered to prevail, and the judge would be able to award attorney's fees and costs as he deemed or she deemed appropriate. Now, if you break that down and think about it, it ought to be between the highest figure that the landowner puts up and the lowest figure that the condemnor puts up. Those are really the extremes that should have been looked at, because what you're trying to do is to discourage landowners' attorneys, because that's what we would do, is put up a high number, and frequently you could have two numbers. You would have the appraiser's number and you'd have the landowner's number. So what was done in the past is you'd have that appraiser's number, and then you'd have the landowner's number would be higher, and you'd be trying to get that jury to bring in a number above the appraiser. Conversely, the condemnor can put up two appraisers, and they would have two different numbers. So we should be discouraging condemnors from putting in arbitrarily low numbers. But Vic Evans, who was then, I think Vic had gone from the Attorney General's office to the DOT at that point in time. He was in-house. He had been a deputy when I was there at the Attorney General's office. Vic was a real manipulator, and Vic convinced the committee, whoever was putting together, that this high thing was the way to go. It really wasn't fair, because it should have discouraged the condemnor, but it didn't. But that's the statute, and that's the statute, and it's not been amended, and I seriously doubt it's going to be amended anytime soon.
So it's not sufficient to get an award for the landowner to get an award. He has to get an award, and the number has to be closer to his higher number.
Correct. Now, as an aside, most condemning agencies will not take that into effect in terms of negotiating a settlement. They make you go get the jury verdict, and if you get the jury verdict, then you get your attorney's fees and costs.
Right. Thank you. Now I interrupted you. Back to, we're down to 7.
Yeah, the second element is the likelihood that the acceptance of the particular employment will preclude other employment by the lawyer. Now, in most firms, if this factor works better if you've got a solo lawyer, a lawyer practicing by himself, because he would be in a situation where he might say, I can't take this case because I've got this other case. Typically, in firms that have any kind of size, what happens is the lawyers who are working on these cases, they can't take as many other cases as they otherwise would, so the work gets shifted to other lawyers in the office, and I suspect that's exactly what happened here. And if you have this happening enough times, what happens is law firms have to add lawyers. So that's the effect of it. And in this firm, these cases, again, primarily the Riverkeeper case, the condemnation case, and the DHEC permit, that would have had an impact on these individual lawyers' workloads, no question. The third element is the fee customarily charged in the locality for similar legal services. And I've already really talked about that. If you use the framework that Mr. Tisdale used, which I would agree with, then you see that the Willoughby and Hafer numbers are significantly under those. The fourth factor is the amount involved and the results obtained. And I think, again, you're looking at 4 ongoing cases, but we've got to take a snapshot of where they are right now. And we talked about the Riverkeeper case and how that had to be fought and how they've already obtained good results by having that penalty taken off the board. That looks like a case that may ultimately have to go to the Fourth Circuit Court of Appeals. That's the only way, if Judge Seymour doesn't change her present position. So until that happens, you're not going to know the full situation. But what we do know is that the standard that's been set so far is an interconnection, which you can't do, a sale of the system, which effectively has happened, or stopping services. They fought as hard as they could and did as much as they could with an incredible standard, and did get that $1.5 million penalty taken off the board. The fifth factor is the time limitation imposed by the client or by the circumstances. And here again, the federal court time limits are just really tough. State court less so because you can get scheduling orders that help you out a little bit, but ALJ also has some tough time factors there too. So you've got, of the 5 cases, really 4 with pressure points. And in a condemnation case or an eminent domain case, those cases, either side can call priority. So at any given time, you know that case might be jumped to the top of the docket and placed for trial. Now, typically, the judges do that when both sides want it, but technically either side can ask for it. The 6th factor is the nature and length of the professional relationship with the client. And as we've already seen in this case, there's a long-time working relationship with CWS between the Willoughby and Hafer firm and it. That is the cause of the reduced and favorable rate. The 7th factor is the experience, reputation, and ability of the lawyer or lawyers performing the services. And I think I've already talked about the high opinion that I have of Mr. Hafer, Mr. Lowell, and Mr. Johnston. And the final factor is whether the fee is fixed or contingent. A contingency fee is one that is based, as the Commission may be aware, is based upon the results that are obtained. In other words, in a typical contingency fee, the lawyer would get a percentage, either a third or 40% of whatever the dollars he gets for his client. Contingency, frequently condemnation cases on the landowner side are taken on a contingency basis, except for corporations. Corporations don't like contingencies, they don't understand contingencies, so they frequently won't do it. In this case, it needed to be on a fixed basis because, and that's to the client's benefit, because if we were dealing with a contingency case and we're dealing with what I think are going to be significant numbers for the value of the business, but would be significant if you were just looking for typical appraised value. If you had, it's typically a fee of a percentage above the deposit or the offer by the condemning authority, but I think it would have been to everybody's advantage to have this on an hourly basis. That's certainly, if I'd been approached about taking the case, that's how I would have taken it. So those are your factors. I don't think there's any question but that these fees are incredibly reasonable. And I think if you break it down and look at it on a yearly basis and you look at it on a case-by-case basis, there's just no question in my mind that these are reasonable fees.
Thank you so much, Mr. Babcock. Would you please answer any questions council have for these commissioners?
Before we continue on, we're going to take a short break, and we'll say 10 minutes. It will be at 3 p.m. according to my watch.